Again, my name is Martin. I'm from ITM Münster, and I want to talk to you about legal aspects of digital preservation. So now come to digital preservation actions and the question, how does these basics I talked about somehow have an impact on digital preservation? What's the intention for digital preservation? Digital preservation could be about conservation of data substance or conservation of operability of services and processes and programs and so on. So first of all, conservation of data substance. No? Okay. So how do I preserve data substance? On the one hand, I can renew the data carrier. On the other hand, I can convert the data. So I just found this picture while we were on the internet. I thought it's pretty funny because all this storage you see here, all the floppy disk and whatever, everything fits on this small SD card. So this is of course the reason why we need to change data carriers, because you have somehow, make sure that the actual data carrier, don't care if it's a floppy disk or if it's a CD or if it's a hard drive, whatever, will still work, or the information is not lost if you can't read the data carrier. So you have to, of course, renew the data carrier. So if I say renew the data carrier, I mean an identical copy of the binary code to the new carrier. So what is an identical copy of the binary code? It's nothing but the permanent reproduction of a computer program, in this case, in whole. So it's a copyright infringement of the exclusive right of the copyright holder. And on the other hand, we have data conversion. So what's a conversion? Somehow it's nothing but a translation into another format. So the translation of a computer, or adaptation or arrangement or whatever, of a computer program is a copyright infringement of the exclusive right, depending on the reproduction right or the adaptation right of the copyright holder. So these two actions of a DP system are infringements of copyrights. And on the other hand, we have conservation of operability of services, processes, and programs. So how do we do that? We could port somehow through porting or migrating the whole process in the system. If we take a look at data migration or software migration. From a legal point of view, I always have to divide between data migration. When I say data, I mean everything except copyrights, because I have to focus on other laws when I check the copyright infringement regarding computer programs. But it's nearly the same, of course. It's the migration is nothing else than a step-by-step transport of something that is copyright protected in a new system. So it can be an infringement of the reproduction right. And if you migrate, if you change something so that it fits to our DP system, and really migrate something into the new DP system, then you alter maybe something of the data or of the software, and so infringe the adaptation or the alteration right of the copyright holder. And of course the same for porting. I mean, porting is nothing else but, not a step-by-step, but a once in whole reproduction or alteration to the new system. So these are also copyright infringement when I start a DP system. So what's the easiest way? The easiest way is, of course, to preserve everything with the consent of the copyright holder. If I have the consent of the copyright holder, then I don't have any kind of problem. But if I don't have the consent of the copyright holder, I have to think about how I can make things work. And now we are on the last step of this three-step copyright basic system. We are on the last step. Exclusive rights are limited by legal exceptions and limitations. We know something is covered by copyrights, and we know that there's an infringement of exploitation rights, or an infringement of exclusive rights of the right holder. And now we search for something like a legal limitation or legal limitation. Just before we start with that, why do I need exceptions and limitations, legal exceptions and limitations? It's pretty easy, because it would be incredibly unfair. I mean, of course, you create something, you're the copyright holder, you should get money for that and whatever. But on the other hand, when you buy something, you buy music on a CD or whatever, you bought it, you have the right to do something with it, to consume the music, to listen to the music in any way. So for example, to make you to create a better understanding of what a limitation is, a limitation that you all use. Promise you, when you buy a CD and you put this music on your iPod somehow, you're of course allowed to do that. It's a reproduction, so it's an infringement of copyright. But you are allowed to do that because we have a limitation in European law that says for private use, you're allowed to reproduce stuff and you won't infringe copyright. So this is what I mean when I talk about copyright limitations. So the first limitation I want to talk to you about is the Article 5 Information Society Directive. I told you that every reproduction in the RAM, in the graphic storage and whatever is a reproduction. It's a copyright infringement. This would lead to the problem that, let's say, if I send you an email, yeah, and this email runs through thousands of servers, and this is all, it's a reproduction and a reproduction and a reproduction and a reproduction. So this won't work, and therefore we have a limitation that says a transmission in a network between third parties and is not an infringement of the reproduction right if it's a temporary act which is transient or incidental and an integral and essential part of the technology process. So the other part of this limitation is the lawful use. So if you, let's say, if you bought something on iTunes or some other store and put it on your iPod or Zune or whatever, and you're all, of course, allowed to listen to that music, and you have to reproduce it, but it's a lawful use. So these temporary acts are covered by this directive. By the way, also this legal streaming some people do in the internet, Kino.to and what there is, this relies on this thing. This limitation does not want to do that, but right now it does. So, but the point is, it only applies to temporary acts of reproduction. So RAM is covered, and cache memories are covered, and online routers are covered, and proxy servers are covered, and whatever. But it doesn't apply to the primary purpose of the digital preservation system, because the main idea is to keep things for ever, at least for 50 years or 80 years or whatever. So we can't use this limitation for our digital preservation system. We only can use this limitation for the reproductions we have to make within the system to make the system run. But that's it. Another limitation is Article 5.2 of the Information Society Directive. That says that the reproduction right from Article 2 is not infringed if the reproduction is done by a natural person for private use. This is what I talked about when I said you can buy a CD and put the music from the CD on a computer and whatever. But this is not the Timbus approach, because what's private use? Private use is the personal purpose of a natural person in a private sphere. So this in no way applies to a business company or to process preservation of a business company. So that won't work. And then we have Article 5.2c Information Society Directive that says public accessible libraries, educational establishments or museums, archives, which are not for direct or indirect economic or commercial advantage, when they can also reproduce stuff, but this is not the Timbus approach. Sadly, they can rely on this limitation, but Timbus talks about business processes and services. So we are, of course, somehow in the commercial sector, and we are not talking about the preservation of museums, of museum stuff or libraries or whatever. So no limitation till now.